To discuss this term and these important cases, we're joined by attorney Adam White, a constitutional scholar and senior fellow at the American Enterprise Institute. Adam, it's great to have you back. This was certainly a big term, one with a lot of hot button issues. They have not shied away from these difficult topics. First, let's get into the Trump election case that was just argued. What is at stake for presidential power?
Well, President Trump has found himself in court in a few different places, but including the Supreme Court. The court's already pushed back against an effort to remove him from electoral ballots in the upcoming presidential election. And now President Trump faces questions over whether he had immunity for the actions he took leading up to January 6th. The court seemed skeptical of the sweeping claims of complete immunity that President Trump's lawyers had advanced. But there were real questions among the justices about how to define the scope of presidential immunity and what kind of factual proof a president might need, or a former president might need, to prove that he had immunity over actions. My guess is the court's going to issue a mixed ruling on that issue and send it back to the trial courts for further development.
Do you think that we could see the kind of push to limit the power of the Supreme Court now coming from the right rather than the left, the way that we saw earlier in the election season?
Well, I don't see a burgeoning call to pack the court as we saw a few years ago. And I served on President Biden's commission to study the Supreme Court in the aftermath of those arguments for court packing. So I'm always wondering where that might bubble up, whether at the federal level or the state level. But mercifully, we've not seen a whole lot of that lately.
That's very good. I agree with you. That's mercy. The Chevron case, then, let's talk about federal regulations, or the case about the fishermen who were forced to have this government monitor on their boat. That's the one that everyone's holding their breath for. Agencies have leveraged their power to force nuns to pay for abortion and contraceptives in their health care plans. You also have the Biden transgender ruling that forces doctors to provide these procedures and hospitals to cover them. Could you see these regulations and these agencies curbed by this case?
Well, the way you frame that, I think, is absolutely right to give a sense of the scope of this. So many of the cases the Supreme Court and the lower courts are hearing now, while we think of them as involving maybe constitutional rights, whether the right to free speech, the Second Amendment, and so on, they're filtered through administrative agencies, and they become questions about the agency's powers under the statutes that Congress has written. But of course, Congress often writes those statutes in very vague or very broad language. And so this case about what you called Chevron deference, this doctrine that the courts will often defer to an agency's interpretation of the law, becomes incredibly important across all areas of law. It's a question about who really is interpreting the statutes. And here, I think the Supreme Court left some real questions after oral argument about what they'll ultimately decide. I don't anticipate a sweeping decision one way or the other, but certainly a recalibration of how much deference agencies are getting, which hopefully will change not just the way the courts go about their work, but also the agencies and maybe also Congress in writing those laws in the first place. It could have a huge effect across areas of law.
One of the questions that came up in oral argument was about the divided Congress. Do you think that the Supreme Court will be taking that into account, their inability to pass laws?
That always hovers in the background of cases involving what Congress has done and what it might do next. But I often think that looking at the gridlocked Congress right now as justifying greater deference to agencies gets things precisely backwards. I think one of the reasons, maybe even a major reason why Congress has become so gridlocked and so inert over the years is the fact that agencies, not Congress, have become the driving force of our politics and our policymaking. The courts have accommodated that largely through the doctrines like Chevron deference. They've taken away a lot of the impetus for Congress to actually act. And so one of the things I'm hopeful for is that if the Supreme Court does tell the lower courts to be less deferential to agencies, that might channel political energy back to Congress. If you want to change a law, don't go to the EPA, don't go to the Department of Treasury, go back to Congress and have them rewrite the law in the first place.
It's going to make for a very interesting election season. Well, let's get into gun cases that impact the pro-life movement, but not in the way that some people might think. If you think about NRA versus Vullo, which would address whether the government is allowed to pressuring companies not to do business with groups or with organizations that it disagrees with. Could this NRA versus Vullo case lead to a state being able to discourage doing businesses with companies that the government doesn't like? So cutting ties with pro-life businesses or with those who support traditional marriage.
Whatever one thinks of gun rights, the Second Amendment, gun control, it is ominous that government officials would try to jawbone banks and others into not doing business with something like the NRA. It's one thing for companies or individuals to voluntarily choose not to give business to an institution, but for government officials to put pressure on others, that's ominous. I think that's one of the reasons why, in this case, if I recall correctly, the NRA was represented by an ACLU lawyer, which is not something you hear every day. But we're seeing more and more of this. Another example, a couple of cases you mentioned, where the Biden administration was pressuring social media companies to take down content that the Biden administration didn't like. Whether it's pressuring the social media platforms, pressuring financial institutions, we're seeing more and more of this kind of passive-aggressive regulatory activity where government is trying to jawbone other institutions, private institutions, into penalizing disfavored institutions and individuals. So I'm watching both the NRA case and also the social media case.
Well, they're important cases to watch also because although the Supreme Court did move on pornography and free speech on pornography, and we'll see something there, the one thing that is looming over them is transgender rights. You know well that sometimes the cases that aren't taken are the most significant. The Indiana parents who had their child removed by family services because they wouldn't use the child's preferred pronouns, talk about ominous. Could the Supreme Court, because it didn't take up that case, take up a case in the future about Kentucky and Tennessee and their bans on transgender procedures for minors?
The court often just declines to take a case for any number of reasons. It might be because the issue at hand is too fact sensitive or other procedural reasons. It's hard to read too much into the court not taking a case, but even when the court doesn't take up a case, that might help to put an issue on the radar of the justices for future cases. So as you're seeing more and more questions about the collision of the transgender rights movement and religious liberty, free speech, parental rights, and on, we're going to see more and more of these cases coming up to the court. The Supreme Court, I think, still has pending a couple of other cases raising some issues about transgender rights and parents' rights. And it'll be interesting to see when the court finally takes up a case.
Absolutely. The scope of parental rights is something we're all looking out for. Well, thank you so much, Adam. Always appreciate your expertise.
Thank you.